The next appeal on this afternoon's calendar is the people of the state of New York versus Frederic Badji, appeal number 7. Good afternoon, council. This is appeal number 7, the people of the state of New York versus Frederic Badji. Council?
Ferguson, you're muted.
Sorry, I have to unmute myself. I thought it was going to be done automatically. Good afternoon, Your Honors. Harold Ferguson for appellant Frederic Badji. We asked for 2 minutes in rebuttal in this particular case.
Sir.
This case presents this court the opportunity to remedy the jurisdictional split between the first and second department on whether or not for grand larceny of a credit card, one needs to have the physical card or simply the numbers on the card. We believe that the analysis done by the second department in Louis C. is the correct analysis, and that when the legislature added 511A to the general business law, they did not cross-reference that to the penal law. And in fact, when the sponsor of that particular legislation made in his memorandum, he stated that Section 511A is created in the general business law, provided that only for the purposes of the general business law, the term credit card should also mean any number assigned to a credit card. It does not.
Chief Judge, if I might ask a question.
Garcia.
If they, instead of creating this 511-A, had put this language in 511 as a separate sub paragraph, let's say 14 or whatever they're up to there, you would agree then it would apply?
Absolutely, Your Honor.
Okay.
That what you had, that
but let me take that a step further then. Okay. So let's say the criminal law, the larceny statute, cross-references in that case where they've dropped it in as 14, 511A1. Would it apply?
If the, you mean if the penal law included 511A1? Absolutely, but it doesn't.
Even though it specifies 511A1 and the new language is in 511A14, your view would be in that case, you would use the expanded definition of credit card.
Yes, because that would be an amendment to 511, not a separate and distinct statute.
But that separate and distinct statute says it applies to the article. So I'm having some trouble seeing the difference between dropping that language as a subsection in 511 with a specific reference in the penal law to 511A1 and dropping it into a different section number 511-A. It seems to me it's just defining a subterm in 511A1.
No, because it says in 511A for purposes of this article.
And what does that mean?
It means Article 29A, which references the general business law. It does not cross-reference it to Title J.
But aren't we getting into a very strange area then? Because they're referencing in the penal law this definition. And that definition has sub-definitions in a way. But what you want to do is limit the cross-reference without the sub-definition. And
Your Honor,
strikes me as leading down a somewhat strange road.
No, it's not a strange road because remember, all of this is happening in 2002. At the same time that the general business law adds this section, at that same time, the legislature also created a series of penal law provisions directly dealing with the situation presented in Mr. Badji's case. Specifically, Penal Law 19081 says a person is guilty of unlawful possession of personal identification information in the third degree when he or she knowingly possesses and then references the numbers on the credit card. Here, what you had simply
Judge,
was.
may I inquire?
Judge Stein.
Yes,
But so 190 .81 is clearly a possession statute, right? And we're talking about theft. My concern, my problem is that I think we're creating this difference in various types of crimes throughout the penal law, whether they're possession crimes or theft crimes. And we're just leaving this one out, which just isn't consistent with what I understood and what I think we previously said was the purpose of the amendments, which was to recognize that a lot of these crimes are taking place without actually getting hold of the actual credit card. So I think my concern is that it leads to a lot of inconsistencies, and it doesn't reflect the fact that possession is different from theft.
Your Honor, but the reality is that when you have the number alone and use it, that's the theft. We have that. The possession of it, knowing that you're going to use it, that's criminalized in 2002. What you have here is that in reality, the legislature poorly drafted 511A. And when you look at the sponsor's memorandum, it can't be more specific than what the sponsor said, that it only refers to the general business law. It does not apply to anything else. And since all of these things are being done contemporaneously.
But 511 says that as well, right?
511 refers to tangible property.
No. 511 says only for purposes of general business law. And 511 is included in Article 22 when 511A says that it's only for purposes of the general business law. So the multiple cross references there or inclusions there, I think make your argument a little difficult.
I respectfully disagree, Your Honor, because again, you have to look at what's going on contemporaneously in 2002, and that is that the legislature is comprehensively trying to deal with these problems. And if they had wanted to, they simply could have amended the penal law as it related to theft of a credit card to cross-reference 511A. They don't do that. Instead, they add
a question, if I'm asking.
Yes, Judge Rivera.
So, counsel, I just want to be clear. Under your interpretation of these various sections and the statutes, these various statutes at play here, what could a person who steals the card and then uses the card be charged with?
The person who steals the card and uses the card is charged with the theft of the card and also the use of the card. It's our position that if a person...
I'm sorry, so just to be clear before you move on, I'm sorry.
Right.
Just to be clear, I just want to understand this. So they would be liable under, or they would be criminally liable or could be prosecuted under both the larceny statutes as well as the identity theft, the personal identifying information statutes. Is that your position?
Absolutely, Your Honor.
Okay, so they could be liable for different kinds of felonies and depending on the facts, maybe only a misdemeanor on the unlawful possession of the personal identifying information, i.e. the credit card number.
That's correct, Your Honor.
Okay, I'm sorry, I interrupted you. I don't know if you want to add.
And again, because they're dealing with this all at the same time, and they certainly could have. It's a problem of drafting. Here, the legislature had the opportunity to cross-reference it to Title J. They did not. They did not cross-reference it to the penal law. The penal law refers to 511. They did not amend the penal law to say that it covers 511A. Therefore, it's our position that this situation, possessing simply the numbers is not in and of itself a criminal offense.
Can I just follow up on that point, Mr. Ferguson?
Yes,
Judge,
Your
is that
Honor.
all right? Yeah, thank you. I guess what I'm struggling with is the logic of the position, maybe on both sides. It seems to me that a plastic card without numbers on it is not a credit card. However, I can go on the internet just using my numbers and buy anything I want up to my credit limit. And that the exercise, the essential element, the sine qua non, to quote our Latin teachers, is the number on the credit card. And the use of that number seems to me to be the criminal act, the act of theft. And the possession of that number is also what constitutes possession for purposes of knowingly possessed. I guess the question has to be, is it essential that you have both the plastic card and the number to be charged with the crime? Because it is not essential for, as we all know, to use that number in a variety of formats, and the card is totally unnecessary.
But when they amended the statute to create a charge for a felony for possession of a credit card and the theft of a credit card, it was to deal with the valuation issue, because it really had no value as just as a plastic piece.
No,
And
but
so
it did
when
have, let me just
Governor
stop you there,
Rockefeller-
Mr. Ferguson.
Yeah.
It did have a value as a number. What's happened though is that commerce has changed, and the number is all you really need to exercise your commercial rights to someone else's credit.
Again, that's absolutely true, Your Honor. But again, what we're getting back to is how this statute is written. And the basic canons of statutory construction are that you go by the plain language of the statute. And the plain language of the statute here indicates that you need the tangible card for it to be this particular crime, not simply the numbers. And we believe that the analysis, the detailed analysis taken by the Second Department in Louis C.
Judge, if I may
is
ask another question. Counsel, what, if any, meaning do you give to the fact that in 155.00 for both credit card and debit card, but I know we're dealing with a credit card here, it says that the credit card means any instrument or article. What, if anything, what, if any, meaning does that carry for this analysis?
all of it goes to that it was a tangible, something that is tangible. When you say article, when you say card, it all is tangible property, something that can be physically held. The number itself is not enough.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Michael Yetter for the people. In 2002, the legislature realized the 1962 definition of credit card was no longer adequate.
Counsel, we're having some
Counsel,
trouble
we're
hearing
having
you.
a little difficulty hearing you. Perhaps if you could raise the volume of your microphone, if that's possible? Or maybe perhaps a little closer.
I'm sorry, can you hear me now?
Not well, but if you keep your voice elevated, I think we'll be able to.
Okay, I'm sorry about that, Your Honors.
It's okay.
The point I was trying to make is that in 2002, the definition of credit card was changed in General Business Law, Section 511A. And my opponent's complaints are basically about the way in which the amendment was done and not about the substance. I think,
Judge, if I may ask.
Yes.
Counsel, it does appear, unlike Judge Garcia's version of including the language about any number associated or assigned to a credit card within 511 itself, it is a little odd to call an amendment something where you have a separate freestanding statute. I find that very odd. The legislature just doesn't do that. This is not a mere drafting error. This is absolutely intentional, and it does strike me as going against every rule of drafting. Can you explain how your position, how one explains that? And it cannot merely be an error.
No, I don't know that it was an error, Your Honor, and unfortunately, I don't think the legislature clearly stated why they went with 511-A instead of a subdivision in 511 itself, like Judge Garcia mentioned. But what they did say is, for the purposes of this article, a definition of credit card shall include any number assigned.
Then how do you explain what are actual enactments of that new suite of crimes dealing with personal identifying information, right, which would include a credit card number, of course, and does so in the statutes that I'm talking about in the penal law, and just at that same moment could have, of course, amended 155.007 to refer to 511-A. Again, my difficulty with your analysis is I have to ignore numerous rules of construction, and the court has to add in language to get to your analysis and your conclusion, and that's where I'm having a challenge. So tell me how we can explain that.
Well, as I think I was trying to state, Your Honor, we believe it is pretty straightforward, both from a reading of the statute sense and also from the statutory legislative history. Again, 511A says, for purposes of this article, the definition shall include credit card number. Of course, the penal law 155 sub 7 cross-references 511. We believe that 511A amends the definition that in 1962 was placed in the general business law. And we think it would be—
Let me ask you this. If let's say I agree with you on that, then how does that explain that if we read it that way, that means that credit card holders get greater protection than debit card holders? And that seems to me to run counter to what the legislature has been doing over and over again. I think Louis C., the court there, pointed to that too. How do you address that issue?
Well, the legislature did not amend 511-9 through 511A. It could have done so, but it didn't. And it might have been concerned at that time with the fact that credit cards they may have seen more instances of fraud related to credit card use than debit card.
Yes, but that's my point. In that suite of new crimes, debit cards are included. So it does seem, and debit cards are added in later after credit cards throughout the penal law and the GBL. So it does seem that the legislature is trying to put the holders on equal footing. And again, your analysis, as Louis C., the court in Louis C. points out, would mean that a debit card holder it doesn't get the same kind of protections. And there's not the same kind of criminalization of that bad act that there is for someone who is a credit card holder.
Right, and I think that's correct under the 2002 definition in the amendment. And I think to the extent Louis C. talks about a debit card, it's correct. But to the extent it talks about a credit card, it's not, because for whatever reason, the legislature decided that a credit card number was something that it needed to include in the larceny statutes. And it would be odd that, given the 30—
Well, it would lead to an absurd result, wouldn't it? Someone steals, looks in my wallet, writes down my credit card numbers and writes down my debit card numbers and goes about the business of using both. But under your scenario, they're only liable on the larceny statute side anyway for the credit card number. It does seem a bit odd, doesn't it?
It does seem odd today, Your Honor, and it's something that certainly is ripe for review by the legislature, but I don't think in 2002 it was necessarily that odd given the situation and the circumstances of revenge was present. And we do think it would be odd that given the longstanding relationship between Section 511 of the General Business Law and Section 155 of the Penal Law, that in enacting this sort of broad legislation to combat exactly the kinds of crimes that we have here, that the legislature somehow intended to pass these new laws that circumscribe or cabin the theft of a credit card only to a physical card, a plastic card itself.
You agree here, though, that the defendant, even though he wasn't charged with it, could have been charged with one of those identity theft provisions?
I believe, yes, that he could have been, based on his use of the credit card, both in the Uber and at the Verizon store.
So in reality, he would have suffered a great deal of criminal, he would have been exposed, let me put it that way, to significant criminal liability if we adopt the reading that defense counsel is arguing for. It's just you've got to do the correct charging.
Well, I mean, the criminal liability on the use, depends on either the dollar valuation or the number of pieces of personal identification information to bump it up. I believe here we would get into felony territory based upon the amount used at the Verizon store. It was over $500. But we just think our reading is consistent both with the text and the history of the statute. And I think, my opponents.
I agree with you. For the single theft at a very low amount, you get the person to have a felony. I think that's what you're talking about.
That's right. And I think that they work together.
But you agree that the legislature could have decided that's not the outcome they were seeking, correct? Even though you think it is, but you can agree that the legislature could have made a decision that that's not the outcome they wanted, correct?
Yes, and I think if they wanted that, they would have made it very clear given the long-standing relationship between those two statutes. So, unless there are any further questions, we believe that the appellate division properly resolved this issue in this case and would ask you to affirm.
Thank you, counsel. Counsel?
Your Honor, both the First Department and the Second Department in Barden and in Louis C. looked at the legislative history of this particular statute, and both came to the conclusion that the legislative history pointed to the interpretation that we are advancing here. In addition, there is the principle of lenity. At best we have here is competing interpretations of what this statute means. And under those circumstances, the canons of construction indicate that the interpretation that should be held by the court is the one more favorable to the defendant, so that even under the principles of lenity, that we should prevail. And I'd like to take just a brief moment or two to address the evidentiary issues that we also raised. One of which is, I think, is very important for this court because it deals with Russell and Sanchez, and going back to a Latin term that was used in an earlier case. The question is whether the sine qua non in having an individual identify someone from a videotape is whether or not there is a changed appearance. It's our position that under Russell and Sanchez, there had to be a changed appearance. Otherwise, the jury itself, which has the opportunity throughout the trial to look at the defendant, can make a determination as to whether that person is the person depicted in the videotape.
Judge DeFiore, may I inquire?
Yes, Judge Stein?
Can't those cases be read as saying that was the reason in those particular cases why the testimony, why the identification was permitted? But I'm not sure that they can be read as saying, though, that is the only circumstance in which.
Your Honor, if the opinions had been written in the disjunctive, I would agree with Your Honor. But they were written in terms of the conjunctive. It was and there was a changed appearance. And I think under those circumstances, and what you're having,
but there's a broader principle involved there, and that is that it would be helped because of some circumstance. Maybe it's a changed appearance, maybe it's a poor quality photograph or video, but something makes it useful, helpful to the jury to have this person who is familiar with the person being identified to testify, to explain. And certainly a change in appearance would fall within that broader principle. But my other question is why was that? If there was error there, identity wasn't an issue here. So why does it matter in this case?
Let me go back to the problem here is how Russell and Sanchez has now been interpreted by the lower courts. As a matter of course now, individual witnesses are allowed to routinely identify people by videotapes and photographs. That can't be the purpose that this court set forth in Russo and Sanchez, that was supposed to be in exceptional circumstances. Instead, what's happened is this is happening as a matter of course now, and this court has the opportunity to correct that. And as to the issue of harm in this particular case, identity is an issue. Because there's a series of evidentiary issues here that are contained in our brief, and I'm not going to go into all the details.
I thought the defense was that he was authorized.
But what you have here is they also have to prove his identity. And the reality here is, absent these evidentiary areas that we have in our brief, there is no live witness who testifies that my client has committed any of these crimes, and that once you remove all of these evidentiary items, the overall impact of these series of evidentiary errors tainted the result and tainted the resolution of this case. And we believe that under those circumstances, this was not harmless. If it was a singular error, it was simply the videotape identification, that would be something different. But it's a series of evidentiary errors. And when they are compounded together, we believe that it becomes harmful error. Thank you, Your
counsel.
Honors.
Thank you.